And welcome back. It's time for Opinion Court. Get in touch with us on 22422, which is our SMS line. And if you're online, please use the hashtag Opinion Court. If you're on Facebook or Twitter, we'd love to follow up with your feedback. Let me, for good measure, just to reintroduce my guests to you and our topic tonight. So to my immediate right is the Senate Majority Leader, Jubilee's Kipchumba Murkomen. Next to him is Bobby Mkangi, who is a constitutional expert, formerly of the Committee of Experts that wrote the Constitution. Next to him is Edward Kisiangani, our resident political analyst. And next to him is NASA CEO Norman Magaya. And gentlemen, you're all welcome to the program. Tonight we are looking at the Supreme Court's full judgment and what it portends in terms of the running of the presidential election on October 26th. We've got exclusive commentary on the same from the chairman of the IEBC, Wafula Chebukati, who responded to Opinion Court's questions on the same earlier today. And let's just show that to him. Opinion Court asked, is it now clear to IEBC what must be done in order to ensure the next poll is credible? Name the specifics that may be different from the way the last election was run. And part of his response reads as follows, that what they will be adjusting in the process includes: 1, adjustments to training manuals to ensure that all processes are done in compliance with the Supreme Court majority judgment, introducing a new set of RO and PO quick guidelines; adjustments to the results path to ensure clarity of all procedures in compliance with the majority decision, including ensuring that forms 34A and B are received by the chairman before announcing results. They also say they have made adjustments to the technology to comply with the Supreme Court's majority decision, including development of a complementary mechanism for the transmission of results, as well as stakeholder involvement. Opinion Court also asked the chairman, what is your understanding of your role in verifying Form 34A in view of both the Kiai decision, which of course was out of the Court of Appeal, and the Supreme Court judgment? In response, the chairman wrote, the Commission will not change the result. The Commission will not change the result as recorded in Form 34A. The result as announced will be final. The chairman will receive all Forms 34A before announcing the result. And finally, Opinion Court asked, will IEBC meet NASA over the irreducible minimums, which they still insist on? And in response, Wafula Chebukati writes, the Commission looks forward to meeting with the presidential candidates and or their agents to go through all the outstanding issues in preparation for the October 26th election. And so those are the responses from IEBC Chairman Wafula Chebukati in as far as their understanding of what needs to happen differently in order to ensure that the coming poll with a new date, October 26th, will not be challenged again in court. And so in studio now, I get down to analysis with my panel, and let's start with the election date. Are we all content with October 26th? Jubilee, happy with the move?
It is not about being happy.
Content?
It's about being ready. And we are ready, we were ready, and we always ready for within the 60 days. And so any date that was going to be picked by IEBC, as long as they were comfortable to deliver fair, credible elections, we were always ready as Jubilee. All right, Nasser?
I think I'll reiterate what I said when I was here a few weeks ago, and that we have no challenge with any date, that we are ready on any date. We, however, have a challenge with the roadmap to that date. To what extent till now has IEBC adjusted its system in realization that things went wayward on the 8th of August, so as to deliver a poll that conforms to the dictates of the Constitution and the election law? And I can say without fear of contradiction that I don't think that has been done. Or if it's being done, then it's shrouded in some form of secrecy that stakeholders are not aware of.
All right. But we've seen from the responses from Wafula Chebukati that they will be engaging at some point. I mean, you were not present at talks that were slated for yesterday, I believe it was. Can we expect that now going forward from today, NASA will be willing to sit down with no preconditions at a negotiating table or at a information sharing meeting with other stakeholders?
Two things, Anne. One, I was in the meeting last week on Friday with Raphael Tuju that agreed on the Wednesday meeting with the IEBC for 2:30. So it's not true to say that we were not ready for a meeting yesterday.
I didn't say you were not ready. I said you weren't present.
But I was present, and after that they wrote to both of us, both to me and Raphael. And again tomorrow they have invited me and Raphael for a meeting to agree on the date, time, and the venue for the next meeting between IEBC and the stakeholders, and we will be attending. But significantly is that if you look at the chairman's answers provided herein, I don't see much difference with the kind of assurances they kept giving us on TV before August 8th. So there must be a commitment that they will do things differently, that they will confront. For instance, here I don't see the chairman confronting the issues he has been putting on his memos, and those things that have been on his memorandum are germane to ensuring that we have an election that conforms with the Constitution. So as long as these critical issues and the things we are raising are not idle, there are things that are serious, there are things that are fundamental to the holding of an election that is free and fair, and there are things that the Commission should be easily comfortable with, because it's not like we are asking for something that is impossible from the Commission. And if they are determined to comply, one, with the Constitution, two, with this judgment of the Supreme Court, and two, to respond to a higher calling that they are an impartial referee to deliver a poll that ensures the unity, that ensures the security and advances the democracy of this country, then they should easily accede to these requests.
Okay, and just for clarity, Opinion Court did seek their position in view of the memos that had been issued, and specifically those seeking, some sort of culpability of officials, and the chairman's response was that he would not comment on leaked memos. Having said that, though, I want to just come back to Jubilee one more time before I open it up to our independent panelists. So what do you think of the Commission's response in terms of what they will do specifically to safeguard this poll from another challenge? Do you believe they have put in the due consideration that ensures that we'll not see another presidential election overturned?
And it must start from the first from the premise that we in Jubilee believe that there is nothing that IEBC fundamentally did wrong in the last elections that warranted the overturning of the presidential elections. Whereas, be it as it may, we have accepted that the Supreme Court has made a decision that we must abide by. We think that that decision was made per incuriam, which is in the ignorance of the facts to the court. And it's now emerging even that there are volumes of documents deposited by IEBC that were not analyzed by the judges. But that is what under the breach in terms of the decision to go back to the elections. We have accepted the flaws that were in the judgment. We think that IEBC can continue, and this is a process of making the elections better. The things that our colleagues in NASA are talking about are beautiful statements about how to make the elections better. But we must remember that IEBC is an independent commission, and that rightly NASA and ourselves and any other citizen of this republic can make as many suggestions as possible, but the responsibility to take in those suggestions, to be able to digest and to collate and to be able to perform their responsibilities for IEBC, and that duty of care as spoken by Supreme Court is a duty that is in IEBC. We have a responsibility as Kenyans to raise these issues. I have no problem with NASA raising as many issues as possible, but it must not be caught in the language of irreducible minimum. We must get this. In any case, there is no choice. Even if you said, if they will not be ready for 26th, and the last day for the elections 31st, if you are not ready for 26th, you can't be ready for 31st.
All right. And I want to come back to my panel, and if you could just get those IEBC responses back on the screen specifically to question 1, which was what they would specifically do differently in the running of the October 26th poll to ensure that it meets rather the court's threshold of being, rather the Constitution's threshold of being simple, verifiable, and accountable. Bobby, your thoughts on their response? They are adjusting training manuals for their returning officers and presiding officers. They are talking about ensuring that 34A and B is received by the chairman before announcing the result, and they are developing a complementary mechanism for transmission of results, which is a significant departure from the last election, where they believe the complementary mechanism could be the manual one, but this seems to allude to an electronic complementary transmission system. Does that meet the bar? And
considering that that was specifically pronounced by the court and ordered that the complementary system as envisaged under Section 44A, which again is birthed by the negotiations that happened last year via the Joint Parliamentary Committee. So that is very central in the preparations that IEBC must put in place. And I think beyond them putting that in place is the requirement that that system must be well understood, must be known to all, and I'm happy that stakeholder involvement is one of the key issues that has been flagged out by the Commission itself. And we want to see more of that continuing. And I hope that the institution of this complementary system will see the input of different stakeholders. And I think that is the path, to me, that has been one of the biggest failures of the institution. When we go back, and I think we also have to remember that there is a history to a lot of what is happening today and what we are seeing today in terms of the institution that is IEBC. And one of the main complaints has been the lack of stakeholder involvement, consultation, and that's why when you look at the Electoral Law Amendment Act, those specifics around consultation, around involvement of stakeholders, and I think in very direct language, and Mheshimiwa here was in the committee remembers that, including political parties, is what eventually is coming to this, and we are waiting to see how that is going to play into today going forward.
Okay.
So I think those are very important. To me, the stakeholder involvement in all the steps and the aspect that the presidential candidates are going to be involved in everything moving forward. You asked about the question of the date earlier, and I agree with Mr. Magaya that it came into question, the October 17th date, in as much as it was stated within the confines of the Constitution. But I think the questions that were raised were fundamental in terms of what engineered that date. And I think the issues that were brought forward, and today we are seeing a change of that date, is what is throwing the entire process and decision-making mechanism into question. Because one may ask, and I'm sure wananchi will want to know, so what did IEBC consider to arrive at the October 17th date? And what has it considered to change the date to the 26th? So I think the process of decision-making, and especially when we consider that we are still in a dispute resolution process, is very key for IEBC and to ensure that all stakeholders are involved in the decisions that it makes, in as much as it is independent consultation and cooperation with all stakeholders, and especially at the end of the day, so that in the eyes of Mwananchi, they can see that this is a process that is agreeable to all is very important.
Okay, and whether you can actually arrive at a process that is agreeable to all, we may have a question mark, but be that as it may, Prof, I want you to move us forward, especially to the question that we asked in terms of the, and this would be question 2, just if we could bring it up for you to see, in terms of verifying of Form 34A and B, and you remember that this was one of the major things that the majority pointed out as a reason for annulling this election, that there was no verifying of the same. And the Commission said to us in response that the Commission will, quote, not change the result as recorded in Form 34A. The result as announced will be final. The chairman will receive all the Forms 34A before announcing the result. And that brings a question of, Prof, what it means to verify that, Form 34A and Form 34B are correct, because part of the thinking is that, you know, the Kiai decision meant that you can't touch these forms. Once it's announced, it is final. And it seems pretty much that the Supreme Court said, okay, no, we actually expect you to verify this information before it's announced. But going by what Wafula Chebukati has responded this evening to us on the same, he says they're not going to be changing that result. He's just going to make sure that he receives 34A and B before announcing the result. Does that meet the demands of the court?
Yes, Anne. Just before I answer that question, let me just quickly also say something about the first question, because it is related. You know, the question number 2 has also been addressed in question number 1, which is adjustment to the results path, ensuring against Form 34A. If you look at the response to the first question by IEBC, there is a very clear admission by the chairman that things went wrong. And in fact, the questions he raised in the confidential reports that you talked about have already emerged in this the answers he's giving in question 1. He is acknowledging there are certain things which did go right. So he says he can address them, including verifying Form 34A. And that means he's telling you that he announced the results without having received Form 34, all the Form 34As. That's why he acknowledges in question 2 that he will do that after verification. So already the decision that has been taken by the IEBC means they have recognized there was a mistake they made. In terms of verification, I think if you go by the minor Kiai decision, the verification is talking about, I think, is to confirm. You can see that again related to the answer number 2 to question 1, he's talking about the path. So therefore, he will try to verify by checking whether or not the Form 34A, which is being relayed by electronically, is the actual reflection of what left the polling station. I think if the polling station recorded a certain number and the agents were this number, I suspect that he will say he will already have the names of the agents at the headquarters, and they will verify and know that they are the ones who signed, and that figure that has left the polling station is the one which is arriving at the bombers at the headquarters. So that is my idea of verification. So he doesn't have to change anything, but he must confirm with his officers that what left the station is what is arriving in Nairobi. And even if it's wrong, somebody has made a mistake on that form, he will not change anything. The second thing I think he will verify, he will confirm that the paperwork which is being used to deliver those results are the correct paper documents that were delivered by the printer. Because those papers, there were problems. Some people are saying some had watermarks, others didn't have security features. So he will have to set up a clear-cut path to identify the security features on the Form 34A and confirm that even if they are photocopied and they arrive in Nairobi, they are the same papers, a reflection of the original that were printed for the sake of these results. So that is my idea of verification, but not changing anything.
Okay,
yes.
First of all, my take from the Supreme Court decision, and actually when I listened to the judges and they talked about the chairman had not announced the results, having not received Form 34A and verified them. The chairman. You know, the chairman works through, I'm assuming the commission works through various officers, including the returning officers in the constituency level who verify results. Even the presiding officer at the polling station is an officer of the commission. The uptake of that is that the chairman must look at all the 40,000.
Wafula Chebukati himself, not somebody else.
Himself. If we are going to be emphasized processes, he must look at 40,000 Form 34As and be convinced that they are Form 34As.
So not that desk that we saw with some two officials and the CEO. Wafula Chebukati himself
has to look at, even if we have not gone to the extent of asking ourselves, in looking at Form 34As, what are the features that he must look at? Maybe the former serial number, whatever the regulations will have said, it coming from the relevant polling station, it came through the electronic transmission. The Constitution requires the Commission to announce results within 7 days. For one person to look at 40,000 forms, for me, it's near to impossible. That takes me to the next issue, is that Then, when they cassette a complementary mechanism, and assuming that now let me come to this. Assuming there are 11,000 forms, 34A, like we were told, that cannot be transmitted electronically, and therefore it takes time, or they be transmitted through complementary system, which, if that complementary system is finally made to be physical transportation of that form, so it is transported to Nairobi, and then physically, then the chairman comes to examine them. It will mean, therefore, that the 7 days constitutional time may never be achieved. And you remember, by the time it was announcing the results, it was at the close, it was actually a day or two, if I can remember. 7 days was 8th, the announcement of results was done on 11th. So he had already expended about, how many days? 4 days. So it was remaining 3 days or so. Assuming now it was going to verify from 34 days, 7 days will be closer to impossible.
But they're talking about the adjustments on the complementary in this answer being a technology-based system.
He hasn't said technology-based.
No. But listen to, let's take a look at the entire response.
Yeah.
We get question 1 up again. He says adjustments to the technology to comply with the Supreme Court majority decision, and including comma. Yeah, but we're talking about adjustments to technology first that will include the development of a complementary mechanism for transmission.
I think in his answer, he's given you 2 answers in one thing. 1, adjust the technology system to comply with the decision of the court. Number 2, development of complementary mechanism for transmission results. He hasn't said whether that mechanism will be manual or technology. But to be fair, I think that is where now the legislature must come in. It will be almost impossible if we were to allow the commission to just function under the confusion created by the Supreme Court, which, by the way, Anne, with almost due respect to the Supreme Court judges who are in the majority, I think were confused themselves about election processes. And luckily, both of them, in the majority and the minority, say that the legislature would have the opportunity to clarify those issues. And I think,
because you've taken us there,
and I think I call upon my colleagues who are in the legislature and being a leader in the Senate, that we must act expeditiously to correct the anomalies that are now going to be created by this decision, and make sure that people can go to elections with clear path having been straightened by the legislature.
How will you
having said that, exactly, Prof, let's pose this question to the whole panel, including you, Norman, because you heard President Kenyatta today, Norman, in his response, saying that he's calling on the legislature to do exactly what he's saying. Are you seeing a situation where electoral laws will be changed before we get to the 26th?
And it is the simple reason I said I've read Justice Njoki Ndung'u's judgment 4 times, because that judgment is a smoking gun. It was intended to provide an entry for the legislature to try and recoup what Jubilee could not get in court. In my understanding, any attempt to touch the legal regime on elections in this country before the next election will create an impossible atmosphere to conduct elections. 2, I think Senator Murkomen is confusing himself as to the interpretation that the judges accorded on the question of verification of Form 34S. They say that the chairman must satisfy himself that these Form 34S and 34Bs have been verified before he announces results. The ruling didn't say that the chairman has to do it himself. And I will give you an example, that on the 8th of August, IEBC had 6 cluster teams for validation and verification of results. But these people are confronted with Form 34Bs without Form 34A. So when you have Form 34B without the source document that is for 34B, for 34A, what are you validating? Okay? So this validation has to be done on the supervision of the Commission through its officers at the National Tallying Center. And remember that one of the elements that was brought out in the Maina Kiai case was the introduction of the election court in the verification process, so that once you are doing the verification to ascertain the accuracy of the figures on this form, if you are confronted with a situation where the figures on Form 34A are materially different from the figures on Form 34B, the chairman is at liberty to quickly ask the election court that there are these anomalies that need correction, so that he gets that order. And it's not a laborious process to do that. It is simply meant to ensure that there is no liberty by election officials to bungle election as they please. The second issue, the second issue, which is problematic when it comes to these amendments that Senator Murkomen is talking about on the election laws. Before you do that, you are faced with an election where you have two protagonists going into this election. Okay? You cannot unilaterally, irrespective of whether you have numbers in the legislature or not, pursue amendments to election laws that soil the environment ahead of the election. They must be understood. They have to be debated. A bipartisan approach must be created so that it's agreed what kind of amendments do we want to do. Because in our understanding, what these guys want to do is to try and open the loopholes for rigging elections through these amendments.
Why don't they tell us exactly what amendments they want passed?
And that entry was provided in the judgment of Justice Njoki Ndung'u.
Okay.
Thirdly, I want to comment on issues that Senator Murkomen has raised as far as these answers are concerned, and I will show you the gaps in these answers. One, that Kenyans vote in a polling station in Kisumu or in Elgeyo Marakwet for that matter, that these results have be transmitted to France before they are wired back to Bomas. It's an absurdity that cannot be allowed to operate in this time and age. One of the things that the Commission must do for the simplicity of the election process, and it's possible to mount servers here that results come straight wired by the telecommunication companies that have been engaged in this process to be able to transmit results to the Bomas of Kenya.
You don't think that was about security, securing the system?
It was never secure, and the court made a finding of fact that the Commission operated in an opaque manner. The court gave it a golden opportunity to be able to rebut the claims that the system was compromised. IEBC cushioned itself by failing to comply with the court order, and the only conclusion that court drew from that action was that actually the system was compromised. So it's a statement, it's a finding of fact that the Commission cannot run.
Let me hold you there. Norman, please, we have to open it up to the rest of the panel.
Just a last comment.
Okay, briefly, sir.
Then he says adjustments to the training manuals. I don't think the problem was with the training manuals. The problem was with election officials who were enticed by entities to compromise the election. Even if you adjust these training manuals and this staff have the same mindset that they have a predetermined objective they want to achieve, they will not look at these manuals. So we must deal with the question of personnel, the competence of the personnel we are dealing with, the impartiality of this personnel to be able to guarantee a free and fair election.
Let's talk about personnel a little later when we come to the issue of criminal culpability. But first, a quick clarification before I open it up to Prof. and Bobby. What amendments specifically will Jubilee be looking to push through before the next election? It's
not about Jubilee, it's about Parliament.
Fair enough.
You know, there is
what will the majority bring?
There's a conversation that is being peddled by people who think that Parliament is going to stop to operate and function just because someone doesn't have numbers in the House. Parliament functions because there is a room for debate. And in many times, particularly in the Senate, where we've always been close in numbers, we've always had an engagement across the board, and you get an idea from a minority or a majority that is able to assist the country. When we were doing the elections laws, we were, you know, we ultimately, even when we amended Section 44A for the complementary system, you know, not all the parts of the minority side did not support the idea. And Parliament still function, and that law is there. So I don't think you want to create this confusion that Parliament is functioning like an arbitration court where people somehow, you know, are looking for consensus. Not even arbitration. Arbitration is the wrong example. It's like a consensus-making body where if you don't reach a consensus, Parliament is about democracy, about majority passing legislation, some people disagreeing and putting in place. And when we open on Tuesday, that is the conversation we will have to ask ourselves, how is this complementary system going to be placed in the constitutional order in terms of when you're talking about complementary system? What are these qualitative analyses that Supreme Court or quantitative analysis must look at when analyzing election results? What are some of the issues you must deal with when verifying results? And what is the role of every particular officer? Once we do that, the Supreme Court has no choice. They cannot go pluck now imaginations of their own. They will have to follow the law. There are many issues that have been raised by the Supreme Court, and I'm not talking about minority. I'm not even bothered about minority decision because it's an opinion. The decision, and it will perhaps be the majority decision in future, and Bob will tell you, and also my colleague here, my colleague in the legal profession will tell you that sometimes the minority decision ultimately becomes majority decision when it's concurred upon later in time. But what is important at the moment is to comply with the majority decision. The confusion that is created by the interpretation of the majority decision, and all over the world, when decisions are made by the court, clarifications are made by legislature to make sure that you put things in conformity.
Let me put it this way to be sure I'm hearing you right. As part of your priority legislation when you open Tuesday, will be to push for legislation that would, if I was to interpret what you're saying, ensure that the quantitative part of an election, which is the actual ballot papers, takes precedence over process, the qualitative analysis and the ability of a judge to overrule the quantitative, the number of votes. We will not be able to exhaust what it means to analyze quantitative or qualitative. But there will be indicators as to what courts can be able to look at when analyzing qualitative and quantitative aspects of an election. Such as?
For example, what is the threshold for arriving at that? What is the place of that qualitative analysis vis-a-vis the quantitative analysis of the votes? When we drafted Article 83, and Bob is here, he was the expert of the other team. He was the expert within the committee, let me put it that way. We picked Article 83 from UK law. But instead of picking it as it is, we changed the analysis of qualitative and quantitative from qualitative and quantitative, and just said or quantitative. And those are some of the things we are going to look at.
Bobby, what I hear more comments saying is they're going to make sure that process does not trump numbers. What do you think of? No. We have to go.
I just want to add something there. Those are some of the suggestions. By the time we are on the floor of the House on Tuesday, Wednesday, Thursday, or the next few days,
it could be a whole other monster.
It could be as many amendments as possible. The minority might bring others and so forth. We'll just consider whatever it's brought to the table. Okay. That is the legislature.
Fair enough. Bobby, number one, the timing of such amendments, will that be in good faith and jeopardize the electoral process too? Is it fair specifically to be touching on something as critical as the quantitative, the numbers, versus the qualitative, the process?
One, I think it is in public domain now that one of the challenges that the election management body had in executing its mandate was the changes that were done quite late in the day. We know that this election laws amendments were done as late as January this year. The new commissioners came in January, and they proceeded to try and deal with so many of the changes that the laws attended to, 6-7 months. And it has been an argument that part of the issues that came about, some of the challenges that came about, were as a result of trying to implement those changes within this short period of time. And,
not a good move is what you're saying.
Exactly. And so I think it is not prudent, in as much as the legislature has those powers, they're not circumscribed as to when they can deal with this. I think it is not prudent of the legislature to try and go and tamper with the legislative arrangement that we have 35 days or less to the elections. And secondly, I think for me, and I said this earlier, this still being a dispute resolution process, the mood should be one of consultation and cooperation.
Agreed.
And I think we've already received some of the responses from the IEBC. I don't think they pointed towards any legislative amendments for them to be able to meet the requirements of the Supreme Court.
But that can stop Parliament from operating as an independent arm.
But I would say that prudently, it is the stakeholder meetings, and I think issues have already been put on the table as to what needs to be done by NASA, and now we are hearing through the senator, the honorable senator, that Jubilee may also have some issues. And I think, to me, this process of coming together, having a political consensus first, and then if that is what will be directed towards legislative process, that is important. Otherwise, I would say it is not prudent for us to go through that path as of now.
Prof, would you say it's leave alone being prudent? Would you say Jubilee then would be acting in bad faith, knowing full well they've got the majority, they can push through whatever they want?
Actually, somebody must contain Jubilee, because they are driven by anger and hatred. And this is everywhere. They are attacking the Supreme Court because the decision didn't go their way. And a few years ago, when the decision went their way, they were praising the judiciary. So we cannot allow them to go to Parliament and then make laws based on their anger, and then pass laws that you never even know what they are going to do. They could go there and start diluting the powers of the judges, the independence of the judiciary, and you can see he's nodding.
Murkomen is throwing his hands there.
Yes. So this is a dangerous political class, and we must deal with them. You know, Murkomen, there's something that he doesn't appreciate, Anne.
What?
He's my friend.
Tell him. He's here.
In 1964, 1964, if you go and check the Hansard report, Raila Odinga's father, Jaramogi, presided over the passing of the Preservation of Public Security Act, which legalized detention without trial in this country. And he was the first victim, and his friends were first victims. In 1969, he was already in detention. You, my brother Murkomen, you are trying to use Parliament to take us back to those days when it was so dark that the police could still arrest you, cause problems to you, because you think you will remain in power for the next 30 years. You know, these laws you are passing, they will be used against you. And when they are used against you, don't complain. Just look at the justice part of the laws. Right now, we have an election which we are supposed to go through. The problem is, even you, with your anger, you don't recognize that the people you have been defending, who are IEBC, have already recognized there was a mistake by their responses.
Prof.
So therefore, they would like to reform, go and talk to NASA, pass something that can be both useful to NASA and useful to what? To Jubilee.
Fair enough, but just before you respond, now, let me ask you this, Norman. What will NASA do if Jubilee, using its majority, manages to pass fundamental changes to the Elections Act before the October 26th poll?
They will go to court.
I think ours.
Let him respond.
I think our position is very clear that the elections intended for 26th October must be held on the same operative legal regime that governed the elections on the 8th of August. The legal regime must remain substantially the same. The mere fact that you are not satisfied with the decision of the court because it has annulled an election does not give you license to go and clog the electoral system so that you get away with whatever mischief that you want to mete out. And so if there is any attempt to amend the election laws, I can assure you, with our earlier stated position, that there will be no election. And this is not an idle threat. Secondly, Senator Murkomen is misleading everyone that during the Windsor process there was an amendment to Section 83. There was no amendment to Section 83. Section 83 was used in 2013 to refuse to annul the election because the judges interpreted it conjunctively, that you had both to look at the qualitative and the quantitative, that if there were irregularities, did they affect the results?
Yes.
The approach and the wording in that section is or. Okay, it is disconjunctive. That did the results, did the irregularities either were they substantial, okay, and two, or whether they affected the results. And that is the approach court took this time round, which was liberal. That they placed premium on the integrity of the process, that if the process was flawed, then the dire result was flawed. And it is not, let me just finish, Anne, and it's not a new judicial principle. It's a well-settled judicial principle, even in legislation, that if the process of enacting legislation in a parliament is flawed, then the act itself is flawed. And many Supreme Courts around the world have pronounced themselves in the same manner.
Bobby, 30 seconds.
Your petition was
Prof, Bobby, you've got 30 seconds before we get back to Murkomen as we're running out of time.
Yeah, because you had asked about that, and it reminded me about the issue of process and form. Yeah. And I think what the court confirmed yesterday, and I remember the Deputy Chief Justice's words, were that the process and the result marry with each other, and they are of similar importance, and that none trumps the other. Because there was a question of the will of the people, translated as the numbers, being more important than how you arrive at those numbers. And I think the court was clear that where there is a will, there is also a way. And that is why the articles that the court relied on, depending on the Constitution, 1, 38, 81, 86, all the way, confirmed that the sovereignty of the people, directed through the electoral ballot, pronouncing their will, has a way of arriving at that. And that is what the court was saying, that if the way of arriving at that will is questionable, then they are not going to entertain
would amending the Elections Act now be part of that process that a court could possibly again consider and say this is meddling with the process that should have given a good result? You have, or is it, how can I phrase it otherwise? Would amending the Elections Act open it up again to more legal battle where one could say this is unconstitutional, this is trying to subvert, you know, what the spirit of the Constitution is in terms of a credible election?
Most definitely, depending on the amendments.
Okay. It depends on the amendment. Okay. I mean, and I think it is, and I want to ask Prof to be a little bit dispassionate in terms of when it comes to defending something that touches on NASA. And being extremely emotional in terms of warning me. But I am very aware of the mandate the people of Elgeyo Marakwet gave me and the people of Kenya
to pass just laws.
To pass just laws. And I'm aware that the courts reserve the right to declare any law constitutional or unconstitutional. Number two is that our friends have been saying no elections without reforms. Now we have told them, come ye,
in Parliament.
Come ye.
Oh my.
We meet at the reform table, bring your suggestions. In fact,
which is Parliament.
Yes, I am happy that my colleagues here are saying that the process is important. We'll make sure that the public participation is as robust as possible. Mogaya, who has no chance to debate in the House, will come to that committee, and Orengo, who has a chance to come inside, will debate with us in the House. I hope they will have resolved their political problems of leadership so that now they can come to the House they have been boycotting, so that then we can robustly debate and agree. And as I said, I'm the majority leader, and I've given public assurance. I am willing to sit down with every legislator of NASA for every minute that it matters, to listen to their point of view for every amendment that will be necessary to make these elections great. But brickmanship and telling people there shall be an election under whose order? There is Kenya, there is IEBC, and I want to dare NASA. Try committing an election offense, and your candidate will be nullified from the elections, and we'll have Uhuru Kenyatta being sworn in Kasarani.
Whoa.
So what is important is that don't think that, you know, we are so used to these insults that we are given all the time that there can be a candidate who is running for elections, is not even in office. The President of the Republic of Kenya, with all the powers conferred to him by the Constitution, has been humble enough to say that he will follow what IEBC will decide because the referee. But when a candidate who wants to use violence to intimidate voters, to make it impossible for elections to be done, he cannot operate in an environment of impunity. In the same way they went to court and we are obeying the court orders, they must obey the Constitution that says that there must be elections and elections will be conducted by IEBC. It is not just the orders of the Supreme Court. It's not about Supreme Court, it is the Constitution.
This will be your final comment, so as you respond, your final comment.
It's good to demonstrate the intellectual dishonesty that my good friend Senator Murkomen is engaging in. One, Senator Murkomen, I was seated next to him in court, and immediately Justice Njokindu proposed that the legislature should take up the matter to look at the jurisprudence without even contextualizing and internalizing the extent of what I mean. He said this one we will do immediately. Okay? Premeditated act. Secondly, it is this arrogance and bravado, assuming that there is no Kenya beyond Jubilee, that is destroying this country. You cannot dictate to Kenyans that you are going to engage them in a process of amending election laws. Remember that these elections, there are 300 and something petitions lying in the lower courts. These cases deserve to be handled under the same legal regime that was there when these cases were being filed. If you are changing the law midway, what happens to these petitions in the lower court? They are best grounded on the same election laws. They are grounded on the same principles. You cannot run away from it by attempting to dictate to the courts. Thirdly, it is not correct when he says that a candidate is dictating to the country. I think the Right Honorable Raila has been very coherent in his communication. He's come out and listed on paper what he thinks needs to be fixed before we hold a fresh election. And if you want to see anyone not interested in a free and fair election, is anyone who will be opposed to those irreducible minimum.
You can.
The last thing I want to say is that they are saying here that IEBC deserves to be independent. None other than the Secretary General of the Jubilee Party has written to IEBC, identified staff he says should be dismissed. Not that they have committed an election offense, he says they are NASA leaning. And they themselves have gone in public pronouncements to say that there was a NASA mole in IEBC who was giving NASA evidence. They are the same people telling you that IEBC should operate as an independent institution. Thirdly, fourthly, they are the same people bearing a lot of importunity, a lot of coercion on the operations of the IEBC to an extent that the chairman cannot even wield the axe on people he thinks have committed electoral irregularities, and none other than the deputy president and the president have told him, don't touch Chiloba, don't touch so and so. Wachana na hiyo ukora yako, go to the election, organize for the election. We are not just looking for any kind of election. We must be honest enough to prepare for an election that conforms with the dictates of the Constitution, that conforms to the wishes of the majority of Kenyans.
But the same way in which you said that if election laws are changed, you will not be there will be no election, and that is not a mere threat. It's the same way Murkomen is now responding to you and saying, I dare NASA to make any election offense, their candidate will be disqualified.
You see, Senator Murkomen needs to internalize. Senator Murkomen, we are not saying anything that is outside the law. Unlike his outburst that borders on dictatorship and impunity. You see, the IEBC has based the decision to allow only 2 candidates in a 2013 court decision. And that court decision is explicitly clear that a contest will be between 2 candidates. Okay? And it's on the basis of that court decision that you must interpret the manner in which this election will be conducted. You are not just looking at the 2017
But when NASA keeps saying there will be no election, we just want clarity. What does that mean? How will you achieve no election? How will you stop an election from happening? I think the president has asked the same question. He says, I am the commander-in-chief and I cannot stop an election from taking place. How will you do it?
Let the president continue with his bravado of being a commander-in-chief. But we can assure you that if the electoral platform is not levelized to allow free expression of the people of Kenya. Remember that the IEBC independence and the conduct of the election is tampered with Article 38, that every citizen is entitled to regular election that is free, fair, and a neutral environment. Okay. If this is not done, we can assure you, without fear of contradiction, that there will be no election.
Final comments, very briefly. You'll have the last word. Okay. Prof, very quickly, you just have under a minute.
I think, just like I observed some time back, we need these 2 parties to meet. They should talk with each other without any stress. Let them recognize that there was a mistake during the last election, maybe not intended, and they sort out that mess. The second thing they should do is this: it is in the interest of the whole country, not where Murkomen has been elected, but the whole country. It's in our interest to have an election which reflects a credible process. It will help our country. And the petition that was in court, Mwanamagaya, was not about the number. It was about the process. NASA gave that petition, but the answer was addressing a different petition. So in this case, therefore, that conflict began from the courts, because you are not talking about the same thing. But the judges have talked about the process. We have time. We may not clean everything and within the shortest time possible. But if they talk and it's give and take, they for some time just expel this arrogance from their domain. We are likely to have a working process, have an election, have a president announced. It doesn't matter whether we agree with the process or not, but so long as the process satisfies the constitutional requirement, we can have a president and give our country some peace.
All right, you've got your last word.
You know, Shakespeare said that it is excellent to have the powers of a giant, but tyrannous to use them like a giant. And unfortunately, I'm seeing two giants using their powers like giants, which is driving us to tyranny. People have been talking about us arriving at a constitutional crisis or a political crisis. I don't think we are headed there. We are already in one. And we need to get out of it. Because if we continue trying to deal with this issue the way we are, by throwing words at each other, by trying to win arguments instead of finding solutions, then I don't think we are being of good service to the children, men and women of this country. I think it is high time that the leaders who have stood up and asked Kenyans to choose them as leaders, to show why they must be chosen as leaders, by, as Professor says, recognizing that, yes, there are problems, and the court is what echoed on the first and yesterday, that there is a problem with our process. We need to rectify it and then go repeat the elections. And I think that is what Wananchi will be looking forward to, and not an exchange of bravado and words on both sides, as we've been having so far.
Welcome, in your final word.
I think, first of all, the foundation of our constitution is majoritarianism, including how we passed the constitution in 2010. Democracy and numbers is the definition of why we have elections. And the majority always must have their way and minority have their say. If majoritarianism was an evil thing, as it's being made to look by Professor and his colleague on the NASA side, it would mean, therefore, that the decision of the Supreme Court yesterday was null and void, because it was decided on numbers. Right. It was 4 against 2. So you cannot tell me you are celebrating a decision of 4 people against the 7 Supreme Court judges, and you walk here and say, oh, this country cannot be led by majority people. We are not apologetic for having the highest numbers of legislators in Parliament, because it's something we are proud of, because it's the overwhelming mandate of the people. And we will use that mandate, knowing, as Bob has said, that the Bible says, those who've been given much is expected. And that's what I'm saying, for our colleagues in NASA, stop the rallies. Now there's an opportunity for you to come and do the job that you always profess in rallies. Come ye, let's reason together in Parliament. And as I've said, we have no fixated position. Come with that reform you've been talking about. Let's sit down. Let's agree as to which areas need to be cleared to ensure that the elections and the processes that will follow the elections, scrutiny and so forth, are going to be done in a transparent manner and in an environment that is acceptable to everybody. Number 2 is that when you tell people that, all that's decision of Njoki, that's profiling one judge. I have said, and I want to say here, that the majority of the court say that the complementary system must be put in place. And that complementary system, they almost actually stopped of saying, had that complementary system been in place, we would not have nullified these elections. We cannot sit here as a legislature to wait for another Supreme Court decision in the end of November and or middle of December, again coming to say the same things. We must provide solutions because the people of Kenya are looking up to the legislature to provide solutions. When 2007 problems came up, it was the legislature that amended the constitution to create the office of the Prime Minister. And it is the legislature that is there, it's working, it's in place to become a solution to problems and challenges that we have might have in this place. Let me assure the country that we in Jubilee are prepared for elections, are prepared for elections being managed by IEBC. We understand that elections cannot be perfect. We are going to live up to the consequences of that decision that is going to be made by IEBC. If the consequences will mean, again, the Supreme Court will decide in December that we go for another election in February, it will be because an independent institution has done that elections, and we hope this time around, and the President has made it clear, that the IEBC must up its socks, must pull up its socks and ensure that there is an election that is free, fair, and credible so that the people of Kenya can progress. Nobody is happy with the situation that we are in. So
much to talk about, such little time. We're back with sport after this with Bernard Dong. My thanks to my guests.